has made hand gestures towards me when I'm speaking, like to make me be quiet. She did that in front of the jury.
Judge, I apologize. Could you step out because I don't want them to try to call you.
Sure. Thank you.
All right.
Oh, well, they've sent a deputy from misdemeanor court to escort Mr. Cox down to misdemeanor court.
Yes.
The only courts that take precedent over felony district courts are the federal courts.
He gave us a hard time because we ran a few minutes late. That was my fault. I have an email here where my client asked to go do laundry and go to the HEB a day ahead of time. And the only response from this pretrial services officer was an email back that just said denied. I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
All right, we're going to take a break. Mr. Cox, they want you in misdemeanor court.
Judge, we just had one witness. It wasn't going to take long.
How long is long?
He has.
Well, they're calling me. They desperately want him in misdemeanor court. I don't understand why people don't understand that there's a hierarchy. And the hierarchy is that district court take precedence over misdemeanor court. District court takes precedent, criminal district court takes precedence over civil court. I don't know why people don't understand that.
Judge, I completely agree and understand what you're saying.
Yeah.
Our witness is out in the hall. He's been waiting.
Oh, well, they've sent a deputy from misdemeanor court to escort Mr. Cox down to misdemeanor court.
Yes.
And I know it's not the deputy's fault. I don't want to make your job any more difficult than it is, but they've sent her up here to take him to misdemeanor court, where the range of punishment goes as high as 1 year at the Bexar County Jail, where we're dealing with the case here, where he's charged with burglary, which the range of punishment is potentially 20 years in prison, but they want him in misdemeanor court. This is the last time, and I want all the attorneys to go forth. This is the last time that this court will be given any type of leeway for people to be out of county in misdemeanor courts, out of county in other courts when you have a jury trial or a bench trial in district court. The only courts that take precedent over felony district courts are the federal courts. I don't know why people don't understand that. So this bench trial is going to finish today. If we're here at midnight, we're here at midnight. And state, I understand that you say your witness is going to be short, but
Judge,
I don't know if it's going to be short.
Judge, the other issue is that he was taking care of a sick parent. He did ask for leave time, and we did get him here despite him taking leave. So it did take extra effort for us to get him here.
All right. So how long is this witness going to take?
Judge, it's going to be quick. He has a maybe 15-minute interview and a video. That's about it.
And it's a video of the defendant?
Yes, Judge.
All right. So what are you bringing this witness for, to lay the foundation for the video?
Yes, Judge.
All right. Defense, are you going to have any objections? If this witness has to appear by Zoom, are you going to have any objections to that? Because if you're going to object to that, then I'm sorry, Deputy, he's not going downstairs.
Say having the witness outside here by Zoom.
Yes, because he has someone who's ill that he needs to be taken care of.
And Judge, I can further explain. He explained it to me this morning.
Okay. Unless my understanding is it's the video and it's the alleged video of your client. Unless you all are going to just stipulate this is the video, and then the court can hear any objections. Otherwise, defense, are you going to have any objections to him appearing by Zoom? And Deputy, I realize it's not your fault.
Would like to have the witness here, since he's here.
All right, then, Deputy, I'm sorry. All right, bring the witness in. Call your next witness.
Renee Munoz and Lorraine Efron.
All right, and are you Mr. Ruiz? All right, you may have a seat. All right, so off the record, my understanding, defense, you've served the defense counsel?
The state.
I'm sorry, the state?
Defense counsel served Brittany Mitchell with a subpoena for a copy of, not just give it to me because they won't give it to me, but to have available the statement of Jordan Lasoya.
All right, so I remember us having a hearing previously about this video, and defense was allowed to have their client view the entirety of the video. So what specifically are, I don't understand what's being
We're
asked
looking
of.
specifically, I'm referring to this in my opening. I mean, may want to show a copy of her video if she doesn't testify the way she testified in the, or the way she's made the statement in the report.
All right, so none of this has happened yet, correct?
No.
She hasn't
No.
testified. So what's the
No.
purpose of serving the
Just so
state?
that we're sure that we're able to get a copy of the video to show if in fact we need to.
State, do you have a copy of the video?
We have a copy available for defense counsel. If that becomes something that they need to do, we can approach and deal with it that way.
All right, so I'm still at a loss as to what was the purpose of serving the state.
The state
When-
may not have it available, Your Honor. Supposedly it's up in their office. I want it to be able to be available if I need to show it.
Okay.
I don't think that would be difficult to do if it's upstairs in their office. They just go upstairs to bring it down. All right, so are you then releasing her or removing your request for her to be under subpoena?
Yes, only for the purpose of this, to show
All right, may
that.
I see the subpoena, please? All right, it says here that she's being subpoenaed to testify. So
No,
you're
That's a
removing her.
mistake. That's a mistake.
All right, so you're withdrawing your subpoena?
Only, yes, Your Honor, because at this point she knows she needs to have that available, yes.
All right, so here's the thing. If people want things available, you all need to talk to each other. You're all officers of the court. Everybody is entitled to a fair trial, both the state and the defense. So just talk to each other. Mr. Garza?
Correct.
All right, defense counsel says there's been some issues with the GPS device. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Julio Garza.
All right, Mr. Garza, are you the pretrial services officer for Luz Eduardo Briceño?
Yes, Your Honor.
All right, so these are the issues and this is what I'm being told. I really don't deal in hyperbole. I just want the facts. So I'm being told that Mr. Briceño has employment. He works construction. And in the defense's motion, it says all hours of the night and required traveling depending on the jobs. All right, we're not going to do the all hours of the night. What I want to know is if he's given a set time where he can be out on employment. Are you going to be able to follow through on that, or do you need him to call in to say he's working employment?
So he would have to provide us the already set schedule for employment.
All right, so here's the deal. It's construction. Usually they don't have a set schedule. And this is from my background in dealing with construction workers and doing a little bit construction myself.
Mhm.
You don't know unless you own the business. You don't know where they're going to send you. They may need you one day in Guadalupe to lay foundation. They may need you one day in Bexar County to put up framing. They may need you one day in Travis County to do tape and float. So my question is, if he's given set hours, let's say, for example, it's Monday through Friday, 7 a.m. to 7 p.m. Can he pick up the phone, call you? If you're not there, leave a message and say, this is Luis Eduardo Briceño, SID number, give him your SID number. I am going to be at the construction site in Bexar County, hypothetically, 300 De La Rosa. And then you can check on GPS. Either he's at 300 De La Rosa or he's not. If he's not, then that's a violation. Are we able to do that?
Honestly, with that, I would have to staff it with my supervisor because I cannot really say.
All
If
right,
the
so-
situation comes to, then, and if my supervisor agrees to it, then yes.
Okay, all right, just a moment. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. State your name for the record.
Oh, Luz Agarro Briseño.
All right. What is your work schedule?
7 to 5 or 6, it depends, 12 hours.
So you're saying 7 a.m. to 5 p.m.?
Yes, ma'am.
What days?
Monday through Friday, Saturday, overtime. And it's, the one I had, it was overnight. There's gonna be night shift, so from 6 to 6 in the morning.
All right, this is what we're gonna do. I'm gonna allow him to work because he's already allowed to work because he's on partial. He's gonna be allowed to work from Monday through Friday, 7 a.m. to 5 p.m. You should have some idea if they're gonna want you to work the graveyard shift. You should know that. I know that much about construction.
Yes, Your Honor.
If he's gonna work the graveyard shift, then counsel, you'll have to send notice to the court that he's working the graveyard shift in the terms of a motion.
Okay.
I will sign it. And then you pick up the phone, you're gonna call your pretrial services officer, and you're gonna say, again, this is Luz Briseño, SID number. I am working at construction site at 300 De La Rosa. You understand?
Yes, Your Honor.
And guess what? If nobody answers, usually a recording will come on. Leave a message. I know sometimes it gets frustrating for people. You don't want to leave a message, but guess what? If you don't leave a message, you didn't call. Do you understand?
Yes, Your Honor.
Is everybody on the same page?
Yes, Your Honor, but may I be heard briefly?
Sure.
Judge, this pretrial services officer is the only pretrial services officer who has ever called me to verify that my client was physically present for a consultation that my client had approval to be at. He gave us a hard time because we ran a few minutes late. That was my fault. I have an email here where my client asked to go do laundry and go to the HEB a day ahead of time. And the only response from this pretrial services officer was an email back that just said denied.
All right. So here's the
Restriction's
thing.
been extremely difficult. So we just asked it to
Well,
be removed from the partial.
No.
I should also tell the court, this is not a family violence case. It's going to be transferred back to CTD.
Okay. No, this is what we're doing. What we are doing is exactly what I said we're doing. He's on partial for work only. If he wants to go do his laundry, if he wants to go to HEB, then that's a motion for another day. We are just partial employment. And this is the court's ruling. Monday through Friday, 7 a.m. to 5 p.m. Understand?
Yes, Your Honor.
If it's going to be overnight, you need to let them know, and counsel, you need to file a motion. That's where we are.
How about if it's on weekends and how?
You need
file a
to,
motion.
you need to file, he'll have to file a motion, and you should know about that before the weekend comes.
Yeah.
And again, you need to pick up the phone, leave a message, and say, this is the location. All right, we're all adults here.
Yes, Your Honor.
Everybody treats everybody with respect. I do understand, and I'm ordering, do I need to order everybody to treat everybody with respect? Okay, I'm ordering everybody to treat everybody with respect, even if internally you don't respect the person, outwardly respect the person. So if you are going to be late, pick up the phone, leave a message with Mr. Garza. This is Luis Briseño. This is my SID number. I'm running late. I'm still at the work site, and GPS will show that you're still at the work site. Do you understand?
Yes, Your Honor.
I understand because I see both sides, right? I understand he's calling, verifying you that you're still at your attorney's office.
So this was 30 minutes in, Judge.
Here's the thing. This is where we are, people. We're starting off at ground zero. I've given everybody my orders. We're gonna follow through with that. Nobody here's a toddler. You know, I'm learning from my niece that toddlers have demands and you need to answer those demands. But so what we're gonna do, Monday through Friday, 7 a.m., 5 p.m., he's allowed to work. Even though I'm allowing you to work, on Monday, when you go to work, if you know you're gonna be at 300 De La Rosa doing construction, pick up the phone, call Mr. Garza. If he's not there, because you're not the only person he's supervising, pick up the phone, call him, leave a message, state your name, your SID number, and I'm at 300 De La Rosa doing construction. You understand?
Yes, Your Honor.
If they send you to another construction site midday, your name, SID number, Mr. Garza, I've been moved to 200 De La Rosa to do construction. Are you able to do that?
Yes, Your Honor.
All right. So that's what we're going to do. And here's the thing that I want everybody to understand. Everybody has a hard day. There are some days where you meet people at their job, and guess what? They've had a hard day and they're taking it out on everybody, and their patience is non-existent. I always try to have patience, and even when I'm having a hard day, I just smile, because you know what? Once you smile, that makes the day better.
Yes, Your
Now,
Honor.
see, your problem has been solved. And then if you want to do the HEB and all of that, that's for another day. Let's solve the problem before me now, and we'll go from there. Now, Mr. Garza, we're off the record. Mr. Garza,
Yes, Your Honor.
is there an email that you maybe want his attorney to send an email saying where he's at as a follow-up, or is just his calling enough?
I would be preferred to be either or, both call and an email. Mr. Briceño does have my email address.
All right, so Mr. Briceño, are you able to email through your phone or no?
Yes, Your Honor.
All right. So then that's what we'll do. And guess what? Having an email, that's good for you because that's a paper trail. All right.
Mhm.
All right. So I am going to order, you're going to be allowed to work Monday through Friday from 7 a.m. to 5 p.m. And if there is a weekend issue, council, just send me the motion if he's working on the weekend.
Sure, and for the further bond conditions that the writ that we're gonna file, can we get a setting today, or would you prefer for me to wait for the writ? to
Oh,
be filed?
you'll have to file it.
Okay.
Okay. All right. Is there anything else?
I was just asking if we could calendar it so I know when to set it.
Oh, no, you can set it with Ms. Ferguson.
Okay.
All right. Is there anything else?
No, would Mr. Garza mind sending me an email directly to my email, which he should have, but it's Joe, J-O-E, @hgclaw.com. And also, would he mind if I asked, does he speak any Spanish? It might help with some of our communication issues.
Yes, I do speak Spanish.
All right. Are you a Spanish speaker?
Yes.
Yes, ma'am.
Oh, okay. All right. All right. If there's nothing else, then that will be that. Okay. All
Thank you
right.
very
Thank you.
much.
Thank you, Your Honor.
Thank you, Judge.
Welcome.
I have signed a few of them at this point,
All right. So has there been any new discovery?
not to my knowledge.
All right, so you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay.
There are a couple of cases that are ahead of you, so those cases may end up going for 4 years. We'll just see where we are, okay?
That's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes.
All right, I'll be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice on
And
the
say that.
courts.
And it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault. when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood. Your
All
Honor,
right,
I'm
thank
trying to
you.
make a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are older
I'm
than
asking
yours.
for a record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Complaints
ends
are
up
being made,
happening,
there should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well, that's
coming
not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we accomplish?
Have a nice
today?
afternoon, sir.
I mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
something's
here's your
gonna actually
reset.
occur.
Sir,
And their courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Yes. All right, so state. My understanding then is you're not trying to say that the defendant was intoxicated?
No, Judge, it's just that one of the ways that he was reckless was that before driving his vehicle was that he was consuming alcohol, that he admitted to consuming alcohol.
All right. And it is in the indictment, counsel. So what is your argument to their argument?
So the first part, Judge, part one is our objection to we anticipate the state is going to try to bring evidence that Mr. Castro was intoxicated. So the first bit is intoxication, Judge.
All right, so let's stop there.
Number one is intoxication.
All right. So are you going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter. He's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right, so defense and state, then with regards to the motion in limine, if you are going to seek to establish that he was intoxicated, y'all need to approach before that's done. But if the only issue is going to be that he consumed alcohol before driving, then the court is going to allow that. And it appears, defense, that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge. That's the first part.
All right.
Judge, can I address
Yes, you may
the second one?
continue.
So, Judge, the second paragraph is obviously, and of course we object to it in the indictment, but we understand it's part of the manner and means that the state is going to try and establish. One of the standards that the state we anticipate is going to try and prove is that Mr. Castro was impaired through the introduction of alcohol into his body. Now, the problem with that, Judge, it's confusing. It hits almost everything in 403. It's an improper legal standard. It's not defined in the code. It's not defined in case law. So we would be asking the jury to make a factual determination based on a made up or non-legal term. So it's confusing and it would ask for speculation. The consumption, we understand, is a court's ruling, Judge. That's fine. But this impaired word is not a legal word. And so we object to any evidence about impairment.
All right, so what happens in courts where there are not legal definitions for words? Do we not use them because there's no legal definition?
I think that's the way that courts, it's defined through case law, Judge, and it's normal usage. But the reason that we object to the word impaired is because impaired is kind of synonymous with intoxicated for a layperson. We know as attorneys that according to the code and law, case law, intoxication is very well defined. And it's clear, it's under 4904 of the penal code, but impairment's not. And so impairment in a juror's mind, despite the court's instructions and explanation, could still be the equivalent of, oh, he was intoxicated then. So it's the same thing. It's like saying, using the word drunk.
But isn't that something to handle through cross-examination?
Well, that might be how the court rules, Judge, and, but that's our argument, Your Honor, and we'll leave it to the court to rule.
All right, defense. I'm sorry, state.
And Judge, again, we disagree. Again, the jury would be able to, just because it's not legally defined, they can use the normal meaning of the word. Again, that's something that it's through defense and statements and just the circumstances around what happened. That's at least something that they can make a determination. And again, we're not trying to say intoxication, but again, it's impaired. That's something that, again, that word may not come up.
All right, so with regards to the balancing test on whether or not that line of questioning should be allowed, I'll need to make that determination at the time evidence is presented. So state, before you have a witness testify that you believe or they believe that Mr. Castro was impaired, we'll just have the jury step out for a moment so I can hear the question and make a ruling with regards to 403. I'm sorry, 403. So on number one, I believe that's been settled, so you can ask questions in regards to whether or not alcohol was consumed. Number two, you'll need to approach.
And Judge, just for the records, number one was more intoxication, number two was impairment, and number three, I apologize, that was consumption.
All right. So, well, number one, that's been granted. You're not going to try to establish that he was intoxicated. Is that correct?
Yes.
All right. So if something changes in regards to number one, then you all have to approach and we'll handle that outside the presence of the jury. But number one, that will be granted. Number two, you'll need to approach. And number three, defense.
Again, I think I know the court's ruling. Again, it's a 403 argument. We'd ask the court to make a balancing determination to see whether any evidence is the risk of confusing the jury, the issues, misleading the jury, substantially outweighs any probative value at the time.
All right, well, number three appears to be that you're not wanting the state to mention that Mr. Castro had allegedly consumed alcohol.
Correct, Judge.
All right, well, that's in the indictment that they're stating that he consumed alcohol. I will, you want a 403 balancing test. Here's the thing, I can't do a balancing test until I hear the evidence, but I will make my ruling when I hear the evidence. But defense, what I'm telling you is the consumption of alcohol is in the indictment. And the state, in their argument, said that your client admitted to consuming alcohol. Whether his admission that the state is alleged he did comes in or not, that's another question. But I really don't see at this point in time how that would be prejudicial.
Again, I just want to supplement that, Judge. I'm sorry, I should have said it before. Case law has established that consumption of alcohol is not illegal. And so to allege that as that consumption of alcohol is a manner of means on its own that is equivalent to recklessness is misleading in itself. And that's my argument, Judge, and we respect the court's ruling.
Okay. All right. So with regards to the consumption of alcohol, state when you are ready to ask a witness whether or not Mr. Castro admitted to consuming alcohol, or however you wish to have the evidence presented that alcohol was alleged to be consumed by Mr. Castro, just approach. And for that part, I'll have you all come forward and I'll do a balancing test.
Yes, ma'am.
All right. So far, does everyone understand the court's rulings? All right, then let's move on to number 4, prior convictions.
Judge, the state's in agreement. The only caveat would be is that if the defendant does take the stand, if there's anything that comes up.
All right, so with regards to prior convictions, if anyone believes that they should be allowed to ask questions about that, just approach before you do so. Extraneous offenses?
Same thing, Judge, if there's any sort of opening the door or that, if the defendant will take the stand.
All right, just approach beforehand. All right, defense, do you have, I know you have the time motion that you wanted to talk about, but before we get to that, any other motions other than that?
That's all, well, for now, Judge, that's all we needed to be ruled upon before we pick a jury. That's it for now from the defense. Thank you,
All
Judge.
right, so then we're going to move on with the state's motion, and they want to have the jury view evidence outside the courtroom. Defense, have you had a chance to review the state's motion?
I have, Your Honor.
All right, defense, are you in objection?
I do object, Judge. Yes, we do.
All right, I'll hear your objections.
Your Honor, and I've got 2 cases for you.
Okay.
And I'll give the state the it's Andika versus State, and one of the cases is one.
Just one moment. The court reporter, it's Andika, Andika, the state. All right. Yes.
So thank you, Judge. So we do, we've seen the state's motion and we object. And based on the case that the state cites in its motion, which is Mauricio versus State, and I can give you a citation if you need it.
Yes, and here's the thing, everyone, when you all are saying cases, because we read case law all the time, court reporter doesn't read case law all the time. So if you all could pronounce it and make sure that if you want your record to be clear, make sure that you spell the case to the court reporter and whatever site you have.
And it's Mauricio versus State, Your Honor, and the citation is 153 Southwest 3rd, 389. And this is the state's own case that they cite. And basically our objection, Your Honor, is that what the state is proposing is an improper demonstration or was a misrepresentation of the scene as it happened on the evening. Now, I don't know what the state is trying to prove by bringing these vehicles here. It's certainly overly prejudicial. It will be misrepresenting the state as it appeared on that day, because obviously you can't recreate, obviously the court doesn't know this, 281 North in the space between the two vehicles where the accident crash site was over a quarter of a mile at least. It'll be a misrepresentation of the crash. And it goes to what the court says in Andika, in the case you've got there, Judge, and I highlighted it, that the court, one of the things that the court can consider is the nature or the deterioration of the scene or the items to be viewed. Now, my understanding, these vehicles have been kept in, what's it called? At the pound, the SAPD pound, and they've been there for 2 years. So the condition that they are in today is not the condition that they were in 2 years ago. They've been outside, it's grounded, and they're outside. So they will have been exposed to the elements. So they will not look today like they did 3 years ago. And the case that the court, the state cites, Mauricio, in that case, that was a demonstration. Mauricio was a demonstration where, and this case isn't Mauricio, this is a case where there was an accident. And we're just going to be looking at the vehicles. Now, what the case law says is, one of the things that the court consider, Your Honor, is that whether that evidence can be obtained from more traditional means, such as photographs and videos, which there are in that big box over there, there are hundreds of them.
Okay, so let me just stop you a little bit because I like to take things one step at a time. So it appears your first argument is that the state may be seeking to recreate the scene on 281, potentially.
Possibly, that's correct, Judge.
State, are you trying to recreate the scene from 281?
Judge, the reason why we gave notice to both the court and to defense is that you could make a determination as to how we present the evidence. If you say that we need to try and recreate it as best, we can try that. If it's just we bring the cars here and we show them, that's up to the court's determination.
But no, my question is, are you seeking to recreate the scene from 281?
No, Judge, because as defense counsel mentioned, that is a very large stretch of highway. What we would do is trying to just present the car so that they can see the condition that they were in.
All right. So then you're saying that you want to just present the cars so that the jury can see the conditions the cars were in.
Yes, Judge.
All right. So then his next argument, and correct me if I'm wrong, he's saying that because the cars have been at the pound in the element, and I don't know if they've been in the element or if they were covered or not, but he's saying cars have been at the pound for over 2 years in the elements. Are those cars in the condition they were in at the time of the alleged crash?
My understanding, Judge, is that they've been left grounded in that no one has gone in and done anything to the cars.
But have the elements changed?
My understanding, Judge, is that they've been covered in plastic and that they have been covered.
All right. So the first thing that the court will need to know, and there will need to be witnesses, I'm assuming, for this to say that the cars were protected from the elements.
Yes, sir.
Because I can understand if the cars were not protected from the element. I'm not a vehicle expert, but I know a little thing about vehicles. If you leave them in the elements, what will happen? Rain, hail, whatever. So I will need to hear from someone. And I don't know if defense is aware if the vehicles have been covered, if they have been protected from the elements. So I would need to know that in order to make a ruling based upon the objections you have. So the state is saying they are not trying to recreate the scene, but they want the jurors to see the state the cars were in after the alleged crash. Then the next question, based upon his argument, is there some other way to do this other than viewing the cars in person?
Judge, even looking at the photos, just due to perspective, it does create issues with recreating the scene itself. So that would be one difficulty. That's why bringing the cars themselves would be important because.
But you said you're not recreating the same.
Or just to bring the cars back to show the condition, Judge, sorry about that.
Okay.
To where, again, just the perspective, the size, damage, things of that nature, it'd be difficult to recreate that with just photographs and with the video, any video alone.
Okay. All right. So defense, they're stating that it will be difficult just through photographs to show the size, which I think we all know that photographs are not, you're not going to show if a car is, 20 feet or whatever, you're not going to bring a photograph that's 20 feet. So they're saying that the photograph will not, I guess, show it as accurately as an in-person viewing of the vehicle. I think that's their argument.
And Judge, with respect, it's not the court. I disagree with that, obviously, because.
Oh, no, I'm just stating.
I
what
know,
they're
no,
saying.
no, Judge, not
Yes.
yourself, but I, with respect to the opposing counsel, I disagree with that. It's standard in any of these cases where people know how big a car is and how big a truck is, Judge. They know that from common experience. Is there anything to be gained from seeing the actual object itself? I mean, and it's almost, it's like a where does this end argument? Because if we're going to do that, then it's still an improper reconstruction. Judge, it's cumulative to as well. I mean, it's a cumulative showing of evidence. That Mr. Escobar yesterday, I don't know if that's their plan. I don't know what the state's plan is for this case. Said he was going to try and do that on Friday. Well, I'm assuming that's towards the end of their case after they will have submitted photographs. So to do that would be cumulative and it would be overly prejudicial because, and again, and I mean, cast no aspersions on the state, and I mean no offense by this, it would be done for the shock value to see the actual vehicles themselves because they're in a terrible state. And that evidence can be put into the record fairly through videos or photographs, which is the norm under the Texas Rules of Evidence, Judge.
All right. And I understand when people say that things can be put in videos or things can be done a certain way, but I'm a firm believer that people should be allowed to present their case however they want to present it. So I do have some questions. So you would be able to have the vehicles brought down
Yes, Judge.
and those arrangements could be made.
Yes, Judge.
And where would the vehicles be placed if they were brought down?
In between the two courthouses, Judge, we've reached out already to SAPD to start to give them a heads up that we're going to be asking if they be brought down. And just a time schedule, really, it's just at this point when the court would allow us to do that so that we can just give them a firm time, give them a firm schedule.
Judge, yes.
Jason Garahan for the record, for the state. I think my suggestion would be is if we could bring them down, no matter what, so you can inspect them if you like, the defense counsel will inspect them before we show them to the jury. And that way you can see from photos that defense counsel has, whether the elements have attached to them or anything has happened. I think that would be the most fair assessment there, Judge. And the state, this is pretty standard throughout the state of Texas that cars are brought in for these type of cases because it shows the amount of damage, the amount of power, the amount of speed that happened during the case. And no photo can give any type of perspective to a juror about the amount of damage. It's just like taking a bed into a courtroom where somebody was stabbed to death. It's brought in because it shows the amount of power, the amount of damage that could possibly happen.
All right. And what I can tell both parties is I'm going to hear your argument. And I was going to suggest that the vehicles be brought down because that will enable me to make a fair ruling. So everybody is, I know you're speaking what the photographs show, but I'll need to see the vehicles as well to make a ruling, okay? But I want to make sure I have everybody's arguments clear, and then I will make my ruling once I see the vehicles. All right, so the other thing is, so what information state are you hoping to gain? Mr. Garahan, I know you mentioned some things you hope to gain from having the vehicles brought down that you're not able to gain through photographs or videos, but if you could just elaborate on that, please.
Yes, Your Honor. Discussion with Mr. Escobar on this case. The actual physical evidence is brought in all the time during cases of gun. so to say, and I know defense probably objects to a lot of guns coming in. But the fact is, this is very similar to that. It's one, in this indictment, it says deadly weapon. One thing that we have to prove that the individual used his truck as a deadly weapon. Hence, we're bringing it in, just like we would bring in a weapon of a handgun or a rifle type caliber. So actually perspective and seeing that in the physical form, one, it shows the power, the amount of energy that was used. One thing that we've alleged excessive speed, that would also be something that the jury can view, and that can only be obtained most of the time from actually seeing it in the physical form.
Anything you wish to add, Mr. Escobar?
No, Judge, I think that was very good summary of what a mile was about to be.
All right. And then counsel, with regards to your argument, the change in appearance, of course, I won't be able to see the change in appearance until we have the photos for me to see and for you to see the photos as it relates to the vehicle. And then, of course, I'll give you both a chance. If you have more arguments, once you see the photo in the vehicle, you can place that on the record as well.
May I very briefly respond to the state's argument there,
Yes.
Your Honor, because from Mr. Garahan, with respect, again, this is what we're talking is a crossover into expert testimony. By looking at an object, a jury of lay people can't tell the power and speed of vehicles. They can make conclusions and assumptions, but Mr. Castro shouldn't be convicted based on assumptions alone and conclusions by lay people. Normally, the predicate for speed and power is laid by expert witnesses, not by viewing an object. And so we object to that. It's cumulative and it's overly prejudicial, but it's in the discretion of the court, and we respect the court's decisions.
All right, we will see, and we will see whether or not there's just a viewing of the object if the court were to rule that the objects were allowed, and whether or not testimony is taken between the Sally Port outside or not. That's something you may want to speak on if it gets to the point where testimony needs to be taken outside. And the reason why I bring that up is based upon the argument that you've just given the court about an expert.
And Judge, and to that point, Judge, in the case that the state cites gives a good roadmap of, the court having to set this up with a court requiring your point, Judge. A court reporter needs to be there in case there are comments made by anybody.
Oh, the court reporter will be there.
Yeah, and just be set up in a way. And again, but we respect the court's decision.
All right. So I've heard both arguments. Is there any? It's you're objecting. It's their motion. Do you have anything else to add?
Nothing else to that, Your Honor. Thank you.
All right. State anything else to add because it's your motion.
No, Your Honor.
All right. Then what we'll do is once the cars are brought, and I think it would probably be best to time the bringing. We can go off the record. I think it would probably be best timing to bring the vehicles is when we're close to any testimony or anything about the vehicles, because I don't want them sitting between the two buildings for any length of time.
And to that point, Judge, I guess they're going to need to have people, SAPD or officers guarding them. Not guarding them, but babysitting.
No, I understand. Yes.
We're taking precautions on that.
Yes.
Because they're not going to be admitted, obviously, right? They're demonstrative evidence, I'm assuming.
Yes. Well, I don't think the court reporter wants to take and her room will not be able to hold vehicles.
Well, I don't know what the state's intention is, Judge. No, I'm like.
All right. So then you say a timing issue, counsel?
I do, Judge, and I'm sorry, Judge, but in the abundance of caution, Your Honor, I know that you will remember, Your Honor, we were here 10 days ago on.
I'm sorry, I don't know. No, we're not on the record. Just go ahead.
No,
Come in,
sorry,
yeah.
okay, Judge, we had a motion on our motion for continuance 2 weeks ago because I was at the CLE.
Yes.
And I've got a copy of the motion here, Judge, for your, and I know you'll remember, Your Honor, I going on vacation on Saturday of this week for 2 weeks, and the court.
Oh, this trial is going to be finished.
Judge, with the greatest respect, this case is that whole box there. Even
Oh,
if we
no,
don't ask the question.
here's the thing. You all are wordsmiths. I know people are not going to be asking questions that do not need to be asked. I'm pretty sure there's not going to be a recross and a redirect. We've had trials in this court and I judge length of time. Is there a video that's 13 hours?
There is excessive body cam.
But is it like over 13
You're
hours?
not playing the portions.
All
But,
right.
it is, there's three body cams that are at least 6 hours long. And then there's one body cam that's 3 hours long.
Well, let me just tell you, my salary is paid by the taxpayers. And guess what? If we need to be here on Saturday, I know nobody has anything to do. I will be here on Saturday. So we're going to get it done.
Judge, if I may, I'm actually, I've got a vacation notice on file. I have non-refundable tickets leaving on Saturday.
Oh, where are you headed?
I'm going to Florida. I'm going on a cruise in Florida.
Let me just tell you, you know what? I've heard so many bad things about cruises.
I don't
I
want to
may
go,
be
Judge.
I may be saving your life.
My wife's making me go, Judge. She'll
Oh.
kill me.
Your wife is making you
She's
go?
making me. Off the record.
Oh, I can't even believe you would say, let's put that on the record. He
I'll put
says
it on
his
the
wife
record.
was making him
I'll
go.
put it on the record. So you won't.
Oh, let me just tell you, this is going to be done. And you know what? If we believe it will be done, it will be done. But if we don't, then we're just putting negative things out in the universe. It will be done.
If I
You
may,
will get on your cruise. What time is your plane?
at 8 a.m. on
8
Saturday.
a.m. Oh, you'll make it.
Your Honor, we are going to the jury for punishment.
You'll make it.
That is, I understand what the court's saying, Judge. I'm the only one who knows really anything about this case.
You'll
from
make it.
our firm. I don't want to bake into the case any ineffective claim. I
You'll
don't,
make it.
with the greatest respect to the court had suggested originally trying it on the 19th.
No, you'll make it.
And again, I understand what the court's saying, but I just want to put it down for the record.
Oh, let's go on the record.
Oh, yeah, we're not on the record. I'm sorry, Judge.
No, because I was hearing what your vacation plans was. So, your defense, you say that you have a vacation letter on file?
I do, Judge. It's in the motion that we considered before.
All right. We will make sure that you make your,
Are there right notes
vacation.
on the back of that, Judge? I might have.
No notes. All right, so, we're gonna start jury trial today. We're gonna go all day on Wednesday.
Yes, Judge.
We're going to hopefully finish this trial before Saturday. All right,
Yes, John.
is there anything else?
Nothing from the state.
May I
Anything
briefly
else?
put some on the record, Your Honor, in
Of
that
course.
case? Then I respect the court's decision, but this is for the record, for my client's benefit and for the future, because this, I'm interested in finality of this as much as the state is and the court is. And it's about fairness to the state and the parties. And I'm concerned that I have a vacation letter on file and I leave out of town on Saturday morning. And I'm concerned that we will not finish this case by Friday. We have elected, or we're electing to go to the jury for punishment, Your Honor, which means getting through the state's case in chief. And they've already indicated that they're not going to bring these vehicles for this jury view until Friday.
Oh, they may end up bringing them sooner. We
They
should
may,
see.
Judge, and they may, Your Honor, but that was what they indicated yesterday.
I discovered sometimes when people think trials will last long, I've had people tell me, oh, this trial is going for 2 weeks. And then they're like, oh, we finished earlier than we thought, and it's in 2 days.
It could happen, Your Honor. When we appeared last time, and I checked last night on the YouTube feed, that we mentioned, the state said it'd be 3 or 4 days, and I've said from the beginning, it's going to be a 5-day trial. Your Honor, I don't know how many witnesses the state are calling or who they don't call, so we may have to present a case. And so then we're asking for the case to be finished by Friday, the jury to be charged and argued, and possibly a verdict with a punishment trial to follow. I'm concerned that it will be ineffective of me if I am trying to concentrate or miss something because I'm worried about trying to rush this case through to its natural end when we could just reset it to
No,
the
I
19th.
say concentrate on this trial because that's where we will be. All right,
I understand, Judge.
all right. So motion for continuance is denied. Anything else from either side?
No, Judge. Nothing from the
All
state.
right, so a jury is going to be called up. We're going to pick a jury this afternoon. And then everyone needs to be here tomorrow at 9 a.m. And we're going to start testimony at 9 a.m. Everybody needs to be ready to go at 9 a.m. 9 a.m. Nobody running in. You know, it's like a plant job. You need to be at your desk and ready to go at 9 a.m. No, we're setting up. Be on the assembly line. Even though you're getting paid at 9 a.m., I will tell you, my mother would always say, her employer would say, you're late if you're not here early. So 9 a.m., all the computers ready, everybody's ready to go. All right? And we're going to come back this afternoon at 1:30 and we're going to start jury selection.
Yes, Judge.
And you're on that, how long, can we have an hour for jury selection each side?
I mean, this is a simple case, is it not?
Nope.
All right, I'll give everybody 30 minutes. Is there anything else?
Judge, can we ask for 45 minutes? It's not a simple case. There are intoxication suggestions, there's causation issues, and the state will probably agree, there are issues with the investigation. There are, Judge. We'd ask for 45 minutes.
35 minutes. Thank you. And counsel, if your client were convicted, it's jury for punishment. Have you filled out the election?
Just do it now, Judge.
Okay.
And he's probation eligible as well, Judge.
Yes,
We're filling out
okay.
the app right now.
And we're looking at probation or 2 to 20, correct?
Correct, Judge.
All right,
Thank
thank
you,
you.
Judge.
Thank you.
She has, as I described with the trial that I had to come in on last month, I've never before been told that I cannot argue on behalf of my client, making valid legal arguments, and that I had to transmit my arguments through another person. And this would be arguments that weren't on a person's witness or something like that. Additionally, she has been cold. She has been insulting at some times. She has said, she has made hand gestures towards me when I'm speaking, like to make me be quiet. She did that in front of the jury. She has treated me as if she is angry or upset with me because of the basis of my grievance.
Well, let me ask you a question real quick.
Yes.
Have you had discussions with her about the grievance itself, or did you give her a copy of the grievance?
I didn't.
So she's never acknowledged to you herself that she's aware of the grievance is pending? To you personally?
She has not acknowledged to me personally she is aware that it is pending.
Has she acknowledged it to anybody that you're aware of?
I understand that the grievance committee contacted her to preserve, because I had asked to preserve the videos and the comments so that they would not be deleted once she was. And I understand that that has happened.
Okay, thank you.
And have the attorneys in her court, attorneys from our firm who appeared in her court been made to wait till the end of docket before they could be heard?
Yes.
And sometimes the entire morning?
Yes.
And sometimes recalled into the afternoon?
Into the afternoon, yes.
So, Mr. Goss, first of all, I've congratulated you, but on the record, congratulations on the birth of your daughter.
Thank you.
Okay. Prior to your daughter being born and subsequent to your daughter being born, have you sought continuances based on your Family Medical Leave Act leave in other courts?
Yes.
Have you ever had any court deny you a continuance on that basis?
No. And I've never heard of any court ever denying any attorney on that basis.
Now, Judge Boyd made the suggestion that, well, we could sever our client out and then you would be able to try the case when you return from your leave. Why is that not an acceptable solution? Because the reason we have the joint defense agreement is because we all believe that it is in our client's individual best interest to have the case tried together, in particular because we each have individual experts for our clients, but we are each counting on the ability to use the other defendants' experts to support our case, as well as if they testify, they are going to testify as a joint front. And we believe that, especially with Nathaniel Villalobos, because of the particulars of that case, and as you can see, he's been charged with something different, we believe that it is important that Mr. Villalobos be tried together with everyone else so that all of their actions can be considered by the jury at the same time, by the same jury that all of us have picked.
And we have met multiple hours. We have gone to the evidence room together as a group, meaning all three defense attorneys, or all three groups of defense attorneys. We have strategized. We have with each other for the last, since the case was indicted in December of 2023. And without, so it puts me in a position of having to advise my client, either you get me or you get your best defense. And it's an untenable position to put me in as an attorney, because I have to take care of my child and my wife and all of those things. And my client has to have the best defense that's available to him. And we have all determined that that is, as the group, and that's why we have joined. And that's why we have a joint defense agreement.
Mr. Goss, concerning the grievance, is the fact that you filed a grievance against Judge Boyd common knowledge in the criminal legal community of Dare County at this point?
Yes, it's been reported in the news. The Sagdala grievance was, that part of the grievance and the fact that it contained me has been reported in, I believe, San Antonio Express News and KSAT. I did not speak to any news organization about it, and I did not make comment about it personally, but I know that Sagdala did.
And do you believe that Judge Boyd has exhibited a personal bias towards you in this case and in other proceedings since that grievance was filed?
Yes.
What's the remedy for violation of the Family Emergency Leave Act?
I'm not sure.
Just curious.
I don't know. I've never heard of anybody violating it.
I mean, I've seen the statute.
Yeah.
Judge, I apologize. Could you step out, because I don't want them to try to call you.
Sure.
Thank you.
All right. Okay, what else we got from Mr. Gospel?
Mr. Goss, you were a prosecutor for a defense attorney?
Yes,
How long were you a prosecutor?
for 9.5 years.
How long have you been a defense attorney? About 6 years, right?
January 2019.
Okay.
Yeah.
In all your years practicing, have you ever seen a judicial officer deny a properly framed and filed motion for continuance under 2906? That was not brought on the day of trial?
Yes, I have seen it. I have seen it one time, and it was reversed.
And has any other judge in Bexar County or the other counties you practice in denied continuances for you on that basis?
No.
Well, I don't know if I passed the witness or just...
I don't know. Y'all are entitled to ask a question if you want to. You don't have to. Okay, you can step down. Thank you.